So if you look at the, I've been indicating that the type of actors related to the type of conduct. Both situations would fit into the title, but they have a very different nature. And of course, they trigger different problems. If we speak then about violations of human rights by corporations, and the ambassador has already made reference to it, I think this is, we have to clarify a couple of things here. Because this can go from, of course, corporations can violate human rights. I'm sorry for the ambassador. Of course they can. Of course it's linked to the criminal law. But we are speaking here about, I would say, violations of international court crimes, which are under the Rome Statute, but also in many conventions. We are speaking about violations of suppression treaties. Think about human trafficking or all illicit trade. Many of these violations are also defined in the international public law and suppression treaties at the global level and regional level, and of course transposed in the domestic criminal codes. And we are also speaking about many situations of, I would say, economic and financial crimes, white-collar crimes, that have a relation with certain human rights. So the concept of violation of human rights, if you put it in such a broad way, such a neutral way also, is enormous. It's enormous, because it's not limited to gross human rights violations, serious human rights violations. You could say international court crimes plus. It's a tremendous broad area of criminal liability. This is running away again. It's incredible. I'm doing something wrong? No, then it's muy sensible. Sí, so in this area, I would say, if we try to come down a little bit and looking at corporations, human rights violations and criminal liability, I would say there are more or less three streams. The first one, of course, has, and this all depends, of course, on the regulatory environment, the enforcement environment in which they operate, domestically and internationally. I would say the first stream is the one of liability of corporations in the sense of the classic development under domestic law. I know that Spain, many people here from Spain, Italy, also Latin American countries, I would qualify them in this stream as latecomers. The criminal liability of legal persons and corporations in particular has a story in many countries which is 100 years old. Not only in the US or in the United Kingdom, but also in certain European countries, including mine in the Netherlands. It started with very specialized offenses, mostly in the economic financial area, or in financial also including customs and taxes, then for economic crimes, and it was expanded in some countries to listed offenses, in some countries today to all offenses. So that means direct, you can have direct liability for manslaughter or for genocide. So this is a very important evolution with, in some countries, a lot of practice. That means it's not only liability in the books, it's also law in action. With many, many advantages, a lot of progress, but also many, many problems. Problems of which type? Problems related, of course, to the definition of the offenses as such, and the definition or the criteria of liability. Because creating direct liability is more the exception than the rule. So it's mostly a system of attributing liability to the legal person through systems of attribution. For what? Not only for lack of prevention, lack of due diligence, lack of control, lack of compliance, of course also for that, but also for direct criminal conduct, both. So the way you can attribute liability is certainly a very difficult exercise under the classic doctrine of liability in criminal law. And it becomes even more difficult when you have situations like the one I described of supply chain, retailer chain, because there you have, of course, you have the main firm, you have the sub-entities, and of course you have third parties or third firms. So that's the reason why we call it a chain. And it's under criminal liability and the responsibility for the chain, not for the actor as such. Also problems of jurisdiction, because a lot of conduct might have been committed outside the jurisdiction of the domestic seat of the firm. Although the firm has under business law or tax law, whatever, a seat, let's say, in a European country, that does not mean that under criminal law there is automatically jurisdiction for conduct in a third country. Also problems, of course, with imposing sanctions. What type of sanctions? To whom? And of course, but that will be your topic, the relation with the CEOs or other heads of businesses in the firm. This first stream is a very important one because, as I said, in some countries it is not limited to corporate crimes in a classic sense, economic financial crimes. It is including also serious violations of human rights, including international court crimes. And in some countries, for instance in the Netherlands, we have specialized units in the prosecutor's offices dealing with, of course, prosecution of international court crimes, including by corporations, and not strictly limited to Dutch corporations, or corporations that have a seat in the Netherlands. A lot of them have, for tax reasons. That's the first stream. The second stream I would say is coming from the international criminal law. So I'm here referring especially to the Rome Statute of the International Criminal Court. But of course this has a long discussion going back to Nuremberg. I don't see there a lot of development at the international public law level. It has been a big achievement, of course, to introduce criminal liability for physical persons, for natural persons, for this type of crimes. We all know that it has not been possible in the legal discussions to introduce corporate liability under that scheme, and I don't see signs that would go in that direction for the time being. However, we must not forget that a very important part of the work on international court crimes is, of course, at the domestic level. So states that include, in my first stream, criminal liability for corporations for serious human rights violations, including international court crimes, of course have it also for the corporations. So they're in the second stream, but only because they have it already in the first, not because they have obligations coming from international public law. The third one, and that's the one I will develop in my contribution most, because of the title, has to do with a very difficult intersection, I would say, between human rights obligations for states, as the ambassador said, under the, of course, states might not violate, but also mostly under the positive duties. States have the duty to protect, and states have the duty, under the positive duties, of course, have the duty to investigate, prosecute, and adjudicate responsibles, natural persons, also corporations, for serious human rights violations. So this duty to provide and the relationship between state liability under conventions, the positive duties doctrine, and then what has to be done at the domestic level in the criminal justice area, in the books, so in the legislation and in action, I think this is a very important field of interaction. This is related, also see my title, with a development that has to do with a increasing accountability of corporations. And of course has to do with the evolution on corporate social responsibility and on responsible business conduct. So where you go from soft law, self-regulation, self-enforcement in the corporate community, based on notions of responsible business conduct and corporate social responsibility, to criminal liability coming from a state scheme, of course, this is a big step. And I have to combine this. And here, I think the positive duties under human rights play a very important role. I know that colleague Laufer will come back on that, so I will be brief on the compliance stuff. But I think it's important to see that this imposition of responsibility and accountability on the corporate community, let's say from a societal context, but also as an internal ethic, has been very important in the last, I would say, 40, 50 years. But it was at that time mostly an ethical internal standard, of course, imposed in a societal context. I would say that corporate social responsibility and responsible business conduct have evolved from a set of ethical standards for market and business morality into relevant standards for corporate liability. And when I say corporate liability, I speak, of course, of a corporate liability under civil law, under administrative law, but also under criminal law. We all know that there has been a tremendous evolution in the United States of America in the civil law under the tort law, and the application at the time of a tort law also for conduct of businesses abroad. We also have seen that in the United States, and there has been case law more recently, in order to reduce the systems of liability and to keep it more, let's say, domestic. I'm sure that also will come back to that. But I would say that the impact of corporate social responsibility and corporate accountability is not limited to civil corporate liability. It clearly extends more and more to an increasing field of criminal corporate liability, at least punitive corporate liability. Some countries limited to administrative law, in some countries administrative and criminal law. You see that already at international public law level. I think if you look at conventions, UN conventions like the UNCAC against corruption, and then the impact on the domestic level, it is clearly that, and of course some very far-going domestic legal devices as the US Foreign Corrupt Practices Act, the United Kingdom Bribery Act, the recent French Sapin II Act, and so on. You see, of course, that this combination of accountability, internal regulations, compliance in the firms, together with punitive criminal liability, is a very important combination and becomes mandatory. Not an ethical standard, but becomes a mandatory legal standard. That means also that companies can be criminal liable and should be criminal liable under many domestic regimes, not only for their direct criminal conduct, but also more and more for failure to prevent, in case of lack of due diligence, in case of excessive risk setting, or for not having at all or not duly functioning codes of conduct or compliance programs. So you already here see that these compliance programs and due diligence and duty of care are not only preventive instruments, are not only instruments of what some of us call privatization of the enforcement, but they're important standards for creating punitive and criminal liability. Finally, and there I go to my main point, in the last decades there have been a growing international emphasis on this link between corporate social responsibility and human rights obligations. corporations should elaborate strategies, policies and strategies to avoid, again the preventive side, being involved in serious human rights violations by applying what is called then human rights due diligence, specifically for that area. And states, so you see their obligations for the corporates and their obligations of course for the states, should develop preventive and repressive policies for gross human rights abuses. I just point out the main sources of these obligations. In fact, since 2005, the UN General Assembly has been adopting soft law, guidelines on basic principles, on right to remedies for victims of gross human rights violations, on responsibility and liability in that area. And I think the most important document guiding principles at that moment, at this very moment, are the principles still of Ruggie, the Ruggie Principle of 2011. So adopted by the UN Human Rights Council, addressed at the business community and special, but also of course imposing duties upon states. First of all, states have the duty to protect against business-related human rights abuses. That means that states are not only liable under international human rights law, of course they are, for violations of human rights by their agents, of course, but they also have, as I said, existing and binding positive duties under human rights conventions. And so true, if you combine this guiding principle with the positive duties, that means that states are under a soft law pressure, under a duty to provide for liability schemes. I don't say that must be for all conduct, illegal conduct, directly criminal liability, but at least liability schemes in the law, and also for effective investigation, prosecution, and punishment, if there is, of course, enough evidence to redress such human rights abuses by corporate actors, and of course also to create remedies for the victims and access to justice, which is also a very important point. Second, businesses have to respect human rights by preventing and remediating human rights abuses. That means they must have in place a policy commitment. They must have in place, as I said, this human rights due diligence process to identify, prevent, mitigate, and account for those for how to address these impacts on human rights, and they must have instruments in place to remediate all this. This is the internal obligations. These obligations are regardless of the size, the sector, the operational context, the ownership, and the structure. So reasoning of businesses, we say, yeah, we are a firm with a, I don't know, a domicile in the Netherlands, and we only have a contractual relation with the subsidiary. No. This obligation applies to the chain. Of course, that's difficult because you have many different actors. You also cannot hide with your jurisdiction scheme in business law or in public law. So that means from these guidelines, businesses have the duty to respect human rights extraterritorially, and also in relation to their production, supply, and retailer chain. As I said, independent from the structure of the parent company, the subsidiaries, and the contract service providers. The third part of these recommendations, or the guidelines of Ruggie, have to do with the remedies for the victims and access to justice. All this sounds very nice, and they are very well elaborated. But we are high in the sky of international public law. This is soft law, and these are guiding principles. Of course, they have been important because states have, at least many states, let me go there again. Help. I move too much. I move too much. No, tampoco. So we have seen that many states have elaborated policies to implement these guiding principles. Also, many firms have done so in their internal policy. But still, the step to criminal liability, of course, there's still quite some gap. And then I think it's important to see that there is a second report of which has been asked by the UN High Commissioner for Human Rights, and which resulted in the report of 2016 of Jennifer Zirk. I think this report is less known, and it's a very interesting one. The title is Improving Accountability and Access to Remedy for Victims of Business-Related Human Rights Abuses. And what is interesting about this report is that, I'm sorry, I'm quoting the wrong title. I'll do it again. The title of the report in 2016 is Corporate Liability for Gross Human Rights Abuses Towards a Fairer and More Effective System of Domestic Law Remedies. So what Zirk is trying to do is assessing the impact of the guidelines between 2011 and 2016 at the domestic level, both in the civil jurisdiction and in the criminal law jurisdiction. The conclusions, I quote a couple of things. The remedies, the present system of domestic law remedies, both civil and criminal, are patchy, unpredictable, often ineffective and fragile. Legal criminal liability for corporations is mostly something present in theory, not in practice. It's not translated into a practical reality. So in the countries where it is in the books, it's not in the action. Why? Zirk is saying mostly due to a significant legal uncertainty surrounding the scope of key liability concepts. There we go. The attribution of liability to the corporate. Unevenness in distribution and use of domestic remedial mechanisms. Political concerns over extraterritorial regulatory and enforcement issues. And general lack of international coordination and cooperation. So this is, of course, a very, very strong conclusion on the ineffectiveness of the application or transposition of the soft law into hard practice. And for some countries also into hard law, but certainly into hard practice. Zirk is also coming up with solutions, at least proposals towards the future. She does not believe that the model of the UNCAC Convention would be the feasible model in criminal law for all serious human rights violations. That's an important statement because I think in the community of international public law and international criminal law, a lot of people do favor this model. So the preventive compliance and then some direct criminal liability in the UNCAC conventions for other fields outside of the corruption area. She is much more insisting on, I would say, jurisdiction issues and cooperation issues. Jurisdiction issues, that means that home states, that means where the main seat of the corporate is based, should take over responsibility, that means also, of course, jurisdiction in terms of criminal law, for the conduct of these corporates outside. That means an increasing of the extraterritorial application of criminal law for this type of offenses. I come back to the Netherlands. I see many times that the public prosecutor's office is saying, we cannot prosecute, although the firm is Dutch, because the conduct has been committed, even by the Dutch firm, outside. Or they say, we cannot prosecute, because the conduct was not committed by the main firm, based in the Netherlands, because they used a subsidiary in a third state, and the subsidiary has no connection with Dutch territory. So that means that you have to create, at least that's a recommendation, you have to create criminal liability and jurisdiction in relation to the chain of control. which is the reasoning also that is coming of human rights, who has control over what. The second recommendation for the future from the Zerk report is extremely orientated on practical cooperation. So mutual legal assistance. And also, of course, training on mutual legal assistance and also changing certain rules in mutual legal assistance. That goes, of course, that includes also rules on discovery, victims' participation, asset recovery, judicial cooperation in criminal matters, in order to make this guidelines more effective in practice. And it's certainly true when you look at many cases that we know that has been prosecuted in certain states. This specialized prosecutor officer or specialized law enforcement agencies, they have great difficulty, certainly with certain states. And I know the cooperation between the US and the European countries, that's mostly not a problem. But when you go abroad, you go really global, then the cooperation mechanism might be very weak or non-existent, both in law and in practice. A last document I want to mention, because there are a lot of documents also coming from the European level, from the Council of Europe, from the European Union. I will not elaborate on them. They are repeating a lot what has been done at the UN level. And in my opinion, it's maybe shameless to say like that, but they don't have real added value for the moment being. However, there's an important document in my eyes coming from an NGO. I'm here referring to the Corporate Crimes Principles, Advancing Investigation and Prosecutions in Human Rights Cases, elaborated by the International Corporate Accountability Roundtable, ICAR, and Amnesty International. The advantage of these principles, if you compare them to the Ruggie principles, they're also soft law, even coming from an NGO, but they focus specifically on the criminal law dimension of this field of impunity. So they want to address the impunity gap in relation to corporate conduct and serious human rights violations. So they try to make the principles much more, I would say, adjusted and concretized to the criminal justice field, dealing with general parts. Think about endangerment crimes, think about attribution of criminal liability, dealing with specific offenses. Think about how do you create offenses for the supply chains and things like that. Dealing with aspects of criminal procedure, whistleblowing, and so on and so on. And dealing a lot also with the jurisdictional issues. And because this, as you have seen already, is of course a very, very important point. Finally, there have been initiatives, and there are initiatives, to turn this soft law at the UN level in a UN legal binding international treaty. In 2014, the UN Human Rights Council did adopt a resolution in that sense, and it established an intergovernmental working group with the aim to explore, let's say, the avenues and possibilities. At the moment being, states are not very much in favor of turning or converting this soft law into hard law, even at the international public law level. States are very much afraid of being imposed upon a binding instrument that, of course, then would be monitored to the UN bodies. And we know that story, of course, of other suppression treaties like the UNCAC and like the UNTOC, the Palermo Treaty, and so on. And they feel that in this broad field of serious human rights violations, that would be that would be a bridge too far for them. So I think that this instrument, for the moment being, will not be adopted, and we will have to do it with the combination between expanding soft law and then making it hard at the domestic level. What does all this mean now for our topic? And I just point out, because many topics, of course, will come back in this two-day seminar. I think that if you look then at from a domestic criminal justice perspective, I think there are very, very important challenges to deal with or to address. It is very clear, I think, from all this evolution, that the liability regime we have in place in classic domestic criminal justice, mostly linked up with natural persons. But natural persons, and Stefano will come back on that, of course, natural persons can have very different features. Under vicarious liability, heads of businesses, or just a natural person committing a crime. But of course, the whole construction of, let's say, dogmatics and liability regimes for corporates is already a tough exercise. But then for corporates in such a broad structure, cross-border, with, as I said, responsibility of control over all the chain, that's even much more difficult. So, and there we are just at the start. Is this possible under? Of course, it is. You can construct a lot of things. You can say, and the topics that will come back, non-financial reporting obligations. Interesting, of course. And you can make that very concrete as part of the compliance regimes, as part of due diligence. You can relate obligations to that in the sense if you don't do it or you don't have it, you're liable under civil law, business law, under administrative law. You can even do that under criminal law, under the notion of fault. So let's say the lack of prevention, the lack of control, I think that's still, under, at least in the tradition who have a strong economic criminal justice system, I think that's easy to do. But there, of course, the sanctions are not very high, cannot be very high. The procedural mechanisms, the investigative tools, cannot be very coercive. So this is, I would say, this is the soft part of criminal law. But of course, when it comes to serious violations of human rights, you're not only interested into have they been complying with their due diligence requirements. You're also interested in can they be criminal liable for the conduct as such. And that's, of course, that's much more difficult. Certainly when there is no, let's say, very clearly with high mens rea intent direct liability. Then you have to construct a thing, and there the dogmatics are weak or non-existent. The same thing I would say for the procedural side. Our laws of criminal procedure are extremely domestic. That's the most domestic and the most national area. It has not been harmonized to a large extent. It has not been harmonized. That means when it comes to investigative tools, it comes to rules of evidence, it comes to applicable safeguards for the corporates, because they have safeguards and they have, as I said, also human rights. It's the patchwork is total. The systems are very different one from the other. Third, and I finish with that, I think that the jurisdiction issue is, and this has to do with domestic law, but has also to do, of course, with international jurisdiction, is also key. We have seen that also in the guidelines, is key. Why? Because member states today, states I must say, nation states today, to a large extent are still thinking in the concept of domestic jurisdiction. So they are trying, of course, in a classic way of reasoning to find a nexus, a classic nexus with the actor and with the conduct. So they're looking for locus delicti, they're looking for the nationality of the perpetrator, and all passive or active and passive, and so on and so on. Of course, here the perpetrator is a corporate. So, yeah, what is citizenship for a corporate? Is that the domicile under business law? Is that the domicile under tax law? So the whole reasoning of a natural person and citizenship and a relation to the nation state of corporates, also something we have to construct. I really believe that they have, if they have social duties, and they of course have a form of citizenship. But that means also responsibilities. Not only for what they're doing in the state of their seat, but also for what they're doing abroad. So there, where the jurisdiction, of course, plays an important role, of course, it means if you construct extraterritorial jurisdiction, the United States has done that a lot in many fields, it means also, of course, that you increase conflicts of jurisdiction, obviously. However, in this field, I think the conflicts are not so important because we see much more inactivity than overactivity and conflicts. So I would not be so much afraid of addressing this conflict of jurisdiction. I think that would be a problem for later. Thank you so much. Muchas gracias. A ver si tú tienes una cabeza más adecuada.
Tengo mucho más, el pelo mucho más corto que el tuyo.
Este es el punto. Este es el punto.
Conmigo va a ser maravilloso.
Bueno. Así que necesito algo para bastante sencillo, ¿no? Así está. Muy bien, que no se mueve. Amigos y colegas, es un placer estar con vosotros hoy y como ya lo dijo Jacobo al principio de esta sesión, ya mis relaciones científicas con la Academia Española, y no solo española, datan de mucho tiempo. Hoy es efectivamente una ocasión para mí para poder dialogar, escuchar mucho lo que se ha dicho, empezando por lo que escuché esta mañana y por todas estas sesiones que se van a desarrollar durante 2 días. Entonces tengo un placer personal estar aquí, tengo un placer científico, porque el tema que se desarrolla aquí, por razones varias que podré mencionar también, cuya responsabilidad le pertenece totalmente al presidente de la Asociación Internacional de Derecho Penal, por razones varias los temas de la responsabilidad penal en conexión con violaciones de derechos fundamentales que tengan relación con el mundo de la empresa me ha ocupado personalmente y profesionalmente durante un tiempo bastante largo. Y pasaré yo también al idioma inglés, no tanto por una aptitud individual específica, sino porque considerando que nuestro público está formado por investigadores de varias nacionalidades y de diverso origen, se preguntó a mí también ayer, por supuesto, que pasara a otro idioma. Lo que haré, disculpando por los defectos que este cambio de idioma seguramente va a producir en mi propia presentación. Antes de hacer esto, quiero agradecerle a Danieto y a Jacobo por la invitación, por la organización y por el esfuerzo de poner aquí alrededor de esa mesa tantas contribuciones varias y seguramente de gran calidad. So, what I'm going to deal with is a topic that has been explored this morning from different perspectives, and that will be, of course, explored in deeper details in the several speeches we are waiting for today and tomorrow. But I have to tell a very short story. When I've been asked to deal with this topic, and it was something like 3 or 4 years ago, what I found in the legal literature was quite poor. Of course, we have been dealing this morning, and there will be a lot of analysis on that, with a certain number of documents issued, in particular by international organizations and by NGOs. And I had to deal for quite an extensive time with these kind of documents and materials, but I was looking for something different because, of course, my perspective, which is the perspective we are dealing with today, and this is the criminal one, or the criminal law approach, has been silent for quite a long time, with a few exceptions that we will need to mention here. So, at the very beginning, I had to compose a sort of puzzle. The picture was extremely fragmentary, at least in my view. This is probably due to my personal capacity, but more in general terms, if you look at the legal literature that has been produced for decades, there is, of course, a very wide mention and effort in terms of theory concerning what has been called the business-related violations of human rights. But in terms of criminal law, the contributions appear to me as being quite poor, at least until a very recent phase. So this puzzle was actually composed by a certain number of documents, and it was even my starting point. And these documents were some of the documents that John Vervaele just mentioned. So the documents produced by the UN at the human rights level, and especially the report by Jennifer Zerk, a certain number of reports, investigation, and position papers issued by non-governmental organizations, which have probably been for a long time the real engine of this mechanism. And what I could actually have as a very fragmented picture at the very beginning, and that I want to share with you as a starting point, and probably something we have to take into consideration even to move to criminal law area, is that we could actually get just a few number of, just a small number of information and elements that I could resume in the following way. Well, criminal law, as I said, was behind the scene. There were just a few offenses reported, but especially a few or very small number of criminal investigations and criminal procedure. What we had in face of us was that accountability for business-related violation of human rights was essentially moving a certain dynamic at in the international arena. And as I said, I could actually find in this very fragmented picture a few elements that could be useful as a starting point. First of all, what kind of business could be implicated in this kind of crimes or offenses? I'm still speaking in a very wide manner. I didn't precise if really speaking or referring to any violation of or serious violation of human rights, or as I think is more useful, to core crimes. But that would be a point I will mention later on. So first point or first question, which are the businesses or the industries, as we can say as well, implicated in this kind of violation? There is a sort of categorization at the international level, very simple made, but it can be useful. On the one side, you have companies dealing with dangerous or violent activities, for instance, providing weapons, or dealing with security services, or even providing for paramilitary forces. And of course, in this area, you have a very high risk of violation of human rights and even of committing international crimes. But then you have to be aware, and we are all aware, that also in ordinary business you can incur in very serious violations of human rights, and you can be held liable. And I will refer to some of the judiciary cases a little bit later in my presentation. Even in the ordinary course of business, normal companies or normal multinational can incur in this kind of liability. If you look at the case law of the recent years, you could actually see that most of the companies that can be considered as be at least indicted or investigated in these cases, they are not the evil which has been mentioned at the very beginning of this morning, but they are probably companies where we also have been in contact as a client or as customers. So that's something we have to keep in mind, because criminal liability for this kind of violation can actually arise in the normal course of business. The second point is, which are the geographical areas interested by this phenomena? And of course, I'm still giving you a very rough picture. Those are the elements that one can find in the current literature, or at least until a few years ago, which are the geographical areas. And once again, if you use two categories, they can be helpful. We have on the one side the victim countries. So the countries where these serious violations of human rights are ordinarily committed or perpetrated. And of course, I'm thinking about countries which are in a developing phase. I'm thinking mostly about African countries. I'm thinking mostly about some Asian countries where these violations have been reported. I also should add some Latin American countries where we are of course aware of the large scale of serious violations of human rights that took place during decades. So in these countries, we can observe easily the fact that serious violations and even core crimes, which are largely connected to business activity, have been committed, but they've been very rarely adjudicated. So local jurisdiction in this case has not really been working well for many reasons we can easily understand. And one of the reasons is that, of course, this country were not in the best position to adjudicate foreign companies acting in their own territory. So the second category of countries that we should look at with a lot of attention is where companies, and especially parent companies, are established. Because in that case, we should add to the first set of countries all the other countries we have in mind: United States of America, European countries, and China. I mean, this is very roughly and very schematically said, but I think it can be even more helpful in terms of dealing with criminal law issues to look at this second group of countries, because of course the case law is arising more from this perspective than from the first one. And third, it could be useful to try to summarize at the international level which are the conducts for which companies can be held liable. And then Jennifer Zerk on the one side, Red Flag, which is an important NGO dealing in this area, and some other, of course, Amnesty, more recent analysis, the International Commission of Jurists, in a very important report which has been produced a few years ago, they all try to summarize in some categories the kind of illicit conducts corporate actors can perform in violating human rights. Well, I have to say that this kind of categorization, in my opinion, are not very satisfying, probably for a lack of criminological reflection on these ideas, maybe for a lack of information, but we are now filling the gap, and I think there is now more room, or at least in the next year, there will be more room for dealing in a more systematic and organized way in this kind of analysis. Let me just mention what you can find in this report, and it's not really very well structured. So companies can be held liable as primary perpetrators, for instance, for forced labor. They can be considered liable as suppliers of goods or services that are used in an abusive way, like, for instance, offering logistics for extraordinary rendition. They can be held liable for providing information or services to state security forces in some authoritarian regimes. They can be held liable for investing or financing some activities that can actually amount to human rights violations. My list is very long. It also includes forcing people to work, engaging abusive security forcing, providing means to kill. But my conclusion on this third piece of information I wanted to put on the table before going to the criminal law issues is that once again we're in front of a very fragmentary, maybe a little bit confused framework, where criminal law has not been the main actor So let's shift to this second point, which is of course at the core of our reflection, even if I still have to insist on the fact that our starting point is exactly the picture and the framework which has been progressively designed at international level. So why criminal law? Well, it's a very rhetorical question, and I'm not going to give an answer to you in a complex manner, but I just want to share with you some thoughts. Of course, criminal law plays a very important role. I think it has been said this morning, it is, or it appears as being, a very effective tool. He has a very strong symbolic dimension, this is for sure. I think that many top officials within corporations have a lot of fear of individual criminal liability. I will come to this point. So it can be very deterrent. But we all know that it's such a powerful tool that it must be used very carefully. I think it has been said this morning, the approach we need when we deal with this issue at criminal law level must be essentially a very selective approach. This is my idea. And that also brings our discussion to something that has been mentioned by John Vervaele. What kind of violations of human rights do we have in mind? Is any kind of serious violation of any kind of violation of human rights? Of course, they would be too broad. Any kind of serious violation of human rights? Well, it depends very much on what we are thinking about, because environmental offenses, for instance, they have a very strong impact on serious violation of human rights. Sorry, on human rights at a large scale. But we don't see any problem in dealing with that, with them, and making companies and individuals within companies to making them liable. The real problem, in my opinion, even from the cultural perception, arises in relation to core crimes. So genocide, crimes against humanity, and other crimes which can be considered as being equivalent. So torture, slavery, and trafficking in human beings. This last category, and I would admit is not a category in itself, that would actually deserve much wider discussion here, but this last category seems to be inconceivable at the level of corporate business activity. We don't see how to reconciliate the idea of ordinary business and crimes against humanity or genocide. So this cultural shock produced by these two elements is the most challenging task we do have, because we know that it can actually occur that companies or individuals within companies, they can be actually accomplices, they can be actually partially or totally responsible for helping, providing means, giving information, financing these kind of activities. So even if we have to consider that this is the most difficult area, this is probably where the contribution of criminal lawyer must be the most intense. And I would also ask that my task is more peculiar, because I've not been asked to deal with criminal law and corporate behavior in general terms, but the title of my speech is much more focused on individual criminal liability. And then other issues arise that probably we need to be analyzed in deeper details. I think that it was totally comprehensible for everybody that we started by dealing with corporate criminal liability this morning. When we think about serious violations of human rights, and even more specifically about core crimes related to business activity, we don't have spontaneously in mind one single person, but we have in mind corporations. And even it has been said, and it has been mentioned in the title of this conference or seminar, multinational companies. Let me remember to you that 40 years ago, in 1979, two very prominent criminal lawyers, Klaus Tiedemann and Mireille Delmas-Marty, wrote the very first paper on these issues, multinational companies and criminal law. At that time, it seems to be totally far away from the reality, but it was not. So, when I come back to my point, I have to say that spontaneously we do consider that making somebody liable for this kind of conduct at the criminal law level should bring us spontaneously towards the organization, the structure, the company itself, the corporation, and more specifically, the multinational corporation. They are extremely powerful. They do perform activities in developing countries. They do have profit as a main objective, of course. They do probably maximize their profit, even in taking in consideration the level of sensitivity and legal regulation in every single jurisdiction. That brings this actor to a very dangerous position, because they could be inclined to commit this kind of violation, or at least to accept that this violation occur under the eyes. But of course, from the conceptual and structural point of view, we could consider that starting by corporate criminal liability is a mistake. We should take into consideration, first of all, individual criminal liability, for at least two reasons. One is a very theoretical and conceptual one. At least in the most evolved legal systems, corporations can be held criminal liable, reflecting the structure of criminal attribution of liability to individuals, to physical persons. So the story of criminal law has been, of course, and I know I say something that is absolutely not new, but our starting point from the conceptual point of view should currently take into consideration first individual criminal liability. And second, even the structure of corporate criminal liability depends on the previous commission of an offense by one or more individuals. So even ascertaining this issue at the judicial level supposes, in most of the cases, we have a certain number of exceptions. We know, of course, that in some systems, corporate criminal liability is actually taken another direction in a more autonomous or independent way. But in the very traditional structure, there will be no corporate criminal liability without any previous commission of an illicit conduct by individuals. So, of course, individual criminal liability of corporate officials is what is our starting point from the criminal point of view when we look at the topic, as I tried very schematically to define and to frame here. So, and let me say that if you look at a very concrete experience, I will refer to a certain number of cases in a few minutes. Of course, mainly individuals have been adjudicated, and then eventually some companies, and that happened in most recent times. So I know I didn't have to demonstrate that, but I just wanted to share this point of view that, in my opinion, is of course central and preliminary to any other remark. So let's move very briefly to something that has been mentioned. And the question I want to put on the table is, starting from this very theoretical or conceptual dimension I try to frame here, do we have any concrete case? So I will immediately move to the case law. And the case law is a very sensitive issue, but is also a very useful and powerful tool to understand whether or not we are dealing with a concrete topic, and if any direction can be defined in this area. That makes me possible to split my analysis very briefly on this point in two different directions. And the two different directions are, of course, the two directions we essentially know. International level, international criminal law, especially international jurisdictions, and domestic judiciary cases. I want to trace this division because I think it's very helpful. In two recent papers, I will actually suggest to you to analyze or to read, if you didn't have the occasion to do that, from two German scholars, Florian Liesberger and Kai Ambos. They created a sort of neologism. They are now talking about Völkerstrafrecht. So something that is a combination of international criminal law and economic criminal law. And I think we are exactly in this area. So we have now to look at both levels and both dimensions, because both contribute, even in a different manner, to shed a light on our topic. So what about case law? Case law at international level is the one that Luis Arroyo is a very profound expert of the history of criminal law, among others. It's what Luis Arroyo mentioned at the very beginning of our works. We have to look behind in the history to have a case law related to that. And of course, I'm referring to the post-Second World War cases under the so-called Council Control Allied Law number 10 of 1945. I know I made a mistake because Chantal, I want you to correct that. So we are now talking about what has been called the Nachfolgeprozesse. So the cases brought in front of the military tribunals in the 4 zones in which Germany was divided after the Second World War, and you are all aware that two jurisdictions had a most prominent role, the United States Tribunal and the British Tribunal. Some of the cases has been mentioned this morning. I'm of course referring to what has been called the industrialist case, or what the prosecutor called the general in grey suits. The idea in the aftermath of Nuremberg was to make liable not just the head of the military, not just the head of the politician fray, but also some industrialists. And that gave rise to a certain number of criminal proceedings we all know. And I'm actually referring, among others, to IG Farben and Krupp. Let me say something that I do consider very important. In the IG Farben case, the defendants were indicted of having used Farben as a tool for committing. Farben was, of course, the most important German conglomerate of chemical. And the defendants were indicted of having used Farben as a tool to commit crimes against peace, war crimes, and crimes against humanity through the production of synthetic fuel and rubber required and used for the wars of aggression by the Nazi Germany. Well, we are all aware that the tribunal was not convinced that the accused really knew about the criminal purpose for which the substance supply were used, because a very narrow circle of people following the reasoning of the tribunal were aware of the plan of aggression elaborated by Hitler. In a second case, I also want to mention, which is the Zyklon B case, which is also known as a Tesh case, adjudicated in front of the British military court in 1946. The defendants were the owner of a firm that arranged for the supply of the poison gas, of course, for the Nazi extermination plan, and two of the suppliers. And they were convicted because the court found that they were aware that the gas was being used to kill internees, and they were sentenced to death. Why I do consider these cases as being extremely important, not just from the historical perspective, but because they include an element we will find a little bit further in my elaboration. They are actually dealing with a very difficult topic: how companies making their ordinary business, and I know it's very sad and it's extremely tragic to mention that here, could be held liable, how individuals could be held liable within these corporations, and how much the mens rea element plays an important role in this field. Please, let's keep it in mind, because in one case that gave rise to conviction, but in other case the individuals were acquitted on the basis of this element. Well, I won't be able, even for reason of time, to deal with a certain number of cases arising at the domestic level. But once again, what I mentioned at the very beginning, please look at what happens in some countries where the company or the parent's company have their legal seats, can be a very powerful way for discovering a case law here. I think one should combine that with a case law arising from jurisdictions that have been submitted to dictatorial regimes during a certain time and then have now a well-established democracy. I'm thinking, for instance, about a certain number of Latin American countries. We are all aware of some of the cases adjudicated in the Netherlands, the Van Aert case, the Koenhoven, I don't know if it's the Koenhoven case. Both cases have been adjudicated a few years ago. They were referring to, one was providing mustard gas to Saddam Hussein, and that brought actually to a conviction of some individuals, and the other one was providing timber woods to Liberian regime. In most recent time, of course, the landscape is very fragmented again, but please consider that there are just a few cases. I mean, some of them are extremely important, but they appear in countries like Netherlands, Germany, and most recently, I would like to mention two cases that are under the attention of everybody and that deserve a particular attention. One is a French case, and the other one is an Argentinian case. I know that here there are for sure a certain number of Argentinians, so I will talk under their control, and please do not hesitate to add afterwards any element that I could actually omit. But at the very end of 2018, a judgment of first instance occurred in Argentina. I think it was in San Isidro, where two of the top officials, well, and more in particular, one was the CEO of a very well-known American producer of cars, Ford, were convicted for complicity in torture because they've been adjudicated for providing the junta militar during the period, of course, of dictatorship, of providing them with information about workers. And this information have been, of course, used for human rights abuses by the junta militar. Apart from the fact that these two convictions amounted to 10 and 12 years of deprivation of freedom are symbolically very important, they also come to conclude a certain number of efforts that the judicial authority has been making in Argentina for several decades in order to make people responsible. So that belongs to one category, and the other category I will mention is probably is still under judgment. Is a public case, and is of course the Lafarge case, the one which is currently investigating in France in relation to the French-Swiss company Lafarge Holcim, and this company, as everybody knows, has been charged for complicity in financing terrorism activities and complicity in crimes against humanity for having provided a certain number of Islamic factions in Syria during the war with financial means. And these financial means in the charges, which are now formally defined by the judicial authorities in France, refer to the fact that despite the conflict, this company wanted their activity to be performed, to continue there, and they needed some protection by the Islamic State, and they paid for that, allegedly being aware of what was happening. And 3 CEO that actually took, had this position during the time are charged currently in France. So let me say, as a very preliminary conclusion on this point, that of course we do have a case law. As you can see, this case law used to be referred to the international jurisdiction or international criminal law, and unfortunately we don't see anything else moving concretely at international level. I would just mention that in a communication of 2016, the prosecutor of the International Criminal Court for the first time said we should focus on economic crimes and environmental crimes, but since then we didn't see anything concrete. And second, much more promising or interesting is, in our view, what arises from domestic jurisdictions. Well, fragmented but very important pieces of case law. What would be my assumption now is that if we want to deal effectively by using criminal law, we must be totally aware of the limits, let's say, of the potential of criminal law, of the limits of criminal law, of the risks related to criminal law. International criminal law doesn't seem to be extremely powerful. Domestic criminal law should combine in a more effective way what comes from international criminal law transposed into domestic jurisdiction and business or economic criminal law. This combination is what I called before the Völkerstrafrecht. Among the different points that deserve attention, I will mention just 2 of them. One, because I don't consider is very relevant, and I will then take a distance from John Vervaele on this point, and the other one because I think it's at the very core of our analysis. The point on which I do not consider we need to improve our criminal law is extraterritorial jurisdiction. I don't feel that extraterritorial jurisdiction is the real problem at the moment. If you look at the cases which have been dealt with by the judiciary in the different cases I was mentioning, they were all territorial cases. There is no problem. I mean, I'm oversimplifying, of course. I personally share the same worries that John mentioned before. But if you look at the practice of the judiciary at the domestic level, when you are dealing with a parent company, there is absolutely no problem in establishing jurisdiction on the basis of a very broad and extended, and maybe for a certain number of issues critical, territorial jurisdiction, because every single state accepts that even if a very little piece of the conduct occurred on the national territory, the war case will fall within the domestic jurisdiction. So we do have a certain number of cases where, of course, the serious violation of human rights has been performed abroad and has been performed at thousands of kilometers away from the place of decision. But the place where the decision took place, or even the place where the omitted control took place, is the place where the company is established. And when the parent company is established in a Western country, I can tell, I mean, it's probably not a very satisfactory solution, but every single jurisdiction will be considered as being, in principle, able to adjudicate the case, the war case. Of course, my thoughts are not reflecting the universal jurisdiction point, because universal jurisdiction is another issue, it's much more complex, that will bring us far away from the discussion. But let me say that in most of the cases, Western countries where the companies are established, they can easily recognize their jurisdiction under the umbrella either of territoriality or active personality principle. So I don't feel personally the need to enlarge that kind of criteria. What I do think is very weak in this area is how do you collect evidence, how do you ensure judicial cooperation, how do you make foreign people that you want to make liable for this jurisdiction appear in front of the court. This is, of course, extremely difficult, but it's more a concrete issue that doesn't really refer to the question of territoriality and extraterritoriality. Well, I was saying before, I will mention one point I don't think deserves special attention. I said also I was oversimplifying, but I wanted to mention this point because I think it's a very sensitive point. And then I will come to my own point that you know is the one we are dealing since the very beginning of my remarks. How do we deal with individual criminal liability? And the the question mark for me is the following one. Do we deal with individual criminal liability of individuals within the company? So, CEO, top officials, directors, but also organs of control, supervisory boards, for instance. Do we deal by making recourse to our ordinary tools? So can we actually rely on the rules on perpetratorships and complicity? Or do we need to enlarge these categories? Or do we need a special legal framework from the criminal point of view? I will be very clear, very transparent on that. In my opinion, we don't need any special tool. We need to deal very carefully with general tools issued both by international criminal law and economic criminal law, and we have to combine them. What I'm saying, in other words, is that there is a risk inherent to the idea that we have to fight against the most heinous crimes committed by the most heinous economic actors. And the risk is, of course, that we cede to the temptation to think that in this area we should make recourse to extraordinary criminal law. I don't think so. I know that it's a very sensitive debate. I know that I will actually need much more time and arguments and capacity of expressing myself in English in order to make it more clear. But at the same time, this is the message I want to deliver to you. We can rely on ordinary, or let's say, specific tools already established in this area. May I have 5 more minutes more?
Yes.
Thank you. Sorry, I was longer than I expected, but it was even a question related to English. So if we look inside this area, which is the area of attribution of individual criminal liability, then I think we have to make a distinction. Well, a certain number of distinctions. On the one side, we have international criminal law and specifically the ICC statute. On the other side, we have domestic criminal law. And of course, domestic criminal law seems to be much more important for the reasons I mentioned. At the same time, it won't be possible to deal today with domestic criminal law using a comparative approach. It won't make sense. We know that there are comparative research in this area. So I will just mention a few points arising from this comparative analysis. And I can summarize them in the following way. First, perpetratorship doesn't seem the most used or recurrent tool. Top officials within corporations are rarely considered as being the main perpetrators of these crimes. Of course, some jurisdictions or some legal scholars make recourse to the very famous Roxin theory related to, of course, to the mittelbare Täterschaft, and especially to the use of an organized system of power. But except for this recourse, you will have a very little number of cases where top officials within corporation have been considered as main perpetrators and have been adjudicated as main perpetrators for that. So we move to the very complex and fragmented area of complicity. And in the area of complicity, we cannot actually, of course, give any general information, but I would like to just to mention here the main areas where problematic issues have arisen. First point, in most of the cases, the actions which are attributed to multinational companies are business as usual. If they are business as usual, they are ordinary, routine activities, providing cars, providing computers to the administration. That was the case in some of the trials. Providing, the gas which can be used as a pesticide or for the Nazi project. So in some of these cases, the issue that arises from the criminal law perspective is that we are in front of neutral acts, of neutrale Handlungen. And that brings to the necessity of making clear what we consider as being as the satisfying level of causality, and that brings also to the need to assess a satisfying level of mens rea. A large part of the scientific debate is around this issue, and we can very easily summarize the results, which are extremely complex and largely overcoming my own possibility today to summarize. We could actually try to say that in relation to neutral acts, the 2 points which have been mentioned also in some cases, in the Saddam Hussein case, in one of the Dutch cases I mentioned before, is that we should be extremely cautious in expanding the mens rea, because if we accept that people can be held liable for neutral acts under the dolus eventualis criteria, then the risk arises that we pass from an under-criminalization to an over-criminalization. 2 or 3 points I will just mention without analyzing them. What about complicity by omission? Because complicity by omission is a very typical kind of imputation in this area. Because in most of the cases, you won't have the directors or the CEO of the companies materially contributing to the crime. That they will in most of the cases, they will close their eyes on the third parties, on the supplier chain. let's think about the textile. What kind of needs do we have to fulfill or to set in order to comply with the general principle of criminal law? Complicity by omission, as I said, or moral complicity in the form of silent consent. Do we consider that as being enough for making individuals liable within the company? Let me say that if you look at the literature in this area, you will, unfortunately, from that point of view, find a certain attempts for expanding general criteria to this very sensitive and difficult case. I think you got my position. My position is in a certain way more traditional, is more classical. I don't think we have to diverge from our general principle of criminal law. So let me say, as a very brief and I'm sure rough concluding remark, that we should think how to reflect all these elements in our future projects and maybe in the criminal policy advancement. So we should try to set our agenda in order to make, of course, more effectively and more fair these kind of prosecutions. I just have a few recommendations that are probably more recommendations for myself than for anybody else. Keep the dialogue open. Let's keep the dialogue open. Let's keep the dialogue open between the different areas of law, of course, international law, tort liability, administrative law, but also, it is for me crucial, ethics and compliance. Let's keep the dialogue open and let's make this concurrent approach of different disciplines as an enriching factor, but without losing the specificities of criminal law, without thinking that criminal law can be the panacea, without thinking that criminal law can be considered for a certain reason the most effective, because we all know the costs related to this kind of instrumentalization of criminal law. Criminal law has its place, has its role, has its functions, and we know them, and we have to preserve them before making recourse to them. So without ceding to any temptation of modifying our cultural approach to such horrible crimes and such heinous conduct committed by powerful actors, and without creating the expectations of the victims that criminal law will be the most effective tool. And my conclusion is somewhat paradoxical, because of course the last attempt I would try to make with you is share the need to find the right balance between this under-criminalization that unfortunately took place for decades, but any attempt to make over-criminalization the aim. We don't need special rules. We need maybe special offenses. It's a very important issue that's been raised by John, of course. Since I was dealing with the criteria for attribution, there was no part of my topic. I think we need to work on the judiciary level. We had to make the judicial activity aware of all the challenges, risks, and potential of making recourse to normal tools for prosecuting this crime. And as I said, my conclusion is quite paradoxical. We have to come back to corporate criminal liability, because in a certain sense, we have to be aware that fighting against individuals, it won't be enough. It's crucial, it's preliminary, but won't be enough, and won't be enough especially for what we have, I think, all as a main aim, which is preventing more than punishing this crime. Thank you for your attention.